sign. Motion carries. One more item that we need to work on this evening before we start. Is there a motion to limit the hearing of this evening for Main Street's petition to 2.5 hours? This was the time we discussed at the last meeting. Is there anyone want to move that we set that time limit?
Is that for just this meeting, or?
This is for all the meetings that it takes to get through this year.
So,
Moved by Bruce, their second. Second by Mike. Any more discussion?
The key is that this is a continuing meeting.
Yeah.
It won't end tonight, rather than.
We have it here now. Anything else? Any other questions on the procedures? Okay. All in favor of the 2.5 hour time limit, say aye. Pose same sign. Motion carried. Okay, that takes care of the kind of housekeeping work we had to do. We have the public hearing now for the Main Street Renewable Power petition number 12-B-1483, known as the Green River Wind Farm Phase 1 application for Ag 1 special use permits to construct turbines and generators in Lee County as part of a wind energy conversion system. So at this point, based on adopting our new rules of procedure, I will turn the meeting over to our new facilitator, Tim Slavin, who we contracted to handle this hearing.
Thank you, Mr. Chairman. Welcome and good evening, everyone. My name is, indeed, Tim Slavin, and I'm a retired judge engaged as an independent contractor to what is called facilitate this hearing. I have no adjudicatory responsibilities. I am not for or against any particular position. I am a neutral. I am here, however, hopefully to add some organization, efficiency, and flow to these proceedings. This is Green River Wind Farm Phase 1 LLC's application for 46 special use permits as part of a wind energy conversion system. As shown by the certificates of publication, notice of this hearing was published in the Dixon Telegraph on June 18, 2012. Notices to adjoining property owners have been provided. All those who so desire will absolutely be given an opportunity to be heard at this hearing. But for everyone's benefit, I want to do it as orderly and as efficiently as possible. There are many possible reasons for anyone's appearance here this evening or at the continued session. You could be a member of the public as a citizen and spectator, part of the applicant's contingent, or an interested party. In this context, an interested party does not necessarily mean someone who is absolutely for or against the requested special uses, but someone who wants to be heard. If you do want to be heard, you will fall into any one or more of 3 categories. Number 1, you want to give testimony. This means you desire, under oath, to testify to facts relevant to the board's eventual decision. Such is not the time to describe your feelings or announce your opinion, but to aver facts, and you are subject to cross-examination. Everyone so wishing to testify will be given one opportunity to do so. Number 2, you want to be able to cross-examine witnesses. But please, this is just the time to ask questions of a particular witness, not to argue with him or her, or not to announce your own opinion. Everyone so wishing to cross-examine will be given one opportunity to cross-examine each and every witness. Or number 3, you want to make a closing statement. This is your opportunity to tell the board how you feel or give them your opinion based on the facts adduced during the whole hearing process as to what their decision should be. Everyone so wishing to give a closing statement will be given one opportunity to do so. Again, everyone will absolutely have a chance to be heard. That is only fair. However, in order to add some semblance of organization, there are 3 half-sheets available to sign up to participate. One indicating your wish to testify, another your wish to cross-examine witnesses, and the last indicating your desire to give a closing statement. These were available at the door and continue to be available at the table to my left from Alice Henkel. While signing up is not, I repeat, not a prerequisite to testifying, cross-examining, or making a closing statement, I will initially be calling on folks using those half sheets, those half sign-up sheets. Only after exhausting that list will I invite others to testify, to cross-examine, or to give a closing statement. If you signed up on one of those half sheets, and it has not already been collected, please deliver it to Chris or Alice Henkel. Please note that once signed up, you will not have to sign up again at each continued session. I will keep those half sheets current throughout the proceedings. Written communications sent in advance of this hearing, or any written material intended as something for the board to consider, is subject to Board Rule Article 5, Section 12, that 8 copies must be provided. Any communications received that did not comply with this requirement may not be considered by the board. Those communications received which conform so far this evening are Exhibits 1, 2, and 3, and they have been marked. And each board member has a copy, and another copy is made as part of the record in this matter. I will now review the chronological progress of the hearing. First, the applicant or his agent makes opening remarks. Second, applicant presents evidence, one witness or one document at a time. I will place each witness under oath or affirmation. Excuse me. After each witness, the board first, and then interested parties have the opportunity to cross-examine. And please, I reiterate, this is just the time for questions directed to the witness testifying. Fourth, interested parties present evidence, one witness or one document at a time, and I will place each of those witnesses under oath or affirmation. After each interested party witness, the commission and or the applicant has the opportunity to cross-examine those witnesses one at a time. Following that, rebuttal witnesses or documents are presented by the applicant one at a time. Following each rebuttal witness, the commission and or interested parties cross-examine applicant's rebuttal witnesses one at a time. Lastly, surrebuttal witnesses or documents presented by interested parties one at a time. Then finally, the commission and or interested parties cross-examine interested parties' surrebuttal witnesses. Finally, the applicant is given the opportunity for closing remarks, and any interested parties are given a like opportunity for closing remarks. Under the board's rules, the zoning officer, Mr. Henkel, would have the opportunity to present evidence, cross-examine witnesses, or make a closing statement. However, Mr. Henkel has indicated to me that he will not be engaging in any of the aforementioned throughout this process. That's the formal rules. Excuse me for a moment while I explain some more informal sub-rules. As you may have heard at the beginning of this meeting, each session has a time limit under the zoning board's rules of 2.5 hours. However, we certainly don't want to cut off anybody right in the middle of something, so I will certainly let someone finish a particular stage when the time limit has been reached. Or, if there is very little time remaining at the end of a stage, I may simply suggest to the chair to continue the session rather than starting on another stage. I do have the discretion to call for short recesses. Under the zoning board's rules, I have the duty to rule on the admissibility of evidence. While the strict judicial rules of evidence do not apply, I will exercise some equitable control of what is being presented, with or without an objection. We do have a co-reporter here this evening taking down what is said during the proceedings. I ask all to be mindful of her job. She cannot take down two people talking at once, nodding heads or gestures, and while I'm sure she is very skilled, there is a limit to how fast a person can talk and expect her to keep up. I do please ask for civility and decorum. This is certainly a public forum, but please be respectful of all who consider it important enough to be here. I ask to refrain from displays of approval or disapproval, and as now with all public gatherings, I ask you to turn your cell phones off or at least put them on silent. Apparently we have a procedural matter first. Mr. Porter, on behalf of Larry Gertis, Stephen Gertis, Friesland Farms, Hamilton Township, Sandra Cruz, Jean Cruz, John Ripkowski, Nancy Ripkowski, Patrick Henry, and Marilyn Henry has filed a motion to dismiss. The legal advisor for the board is the State's Attorney, the Honorable State's Attorney of Lee County, Mr. Dixon. You received a copy of that motion. I'll turn that matter over to you. Mr. Porter, actually, I guess it's unfair. You filed the motion. Do you want to make an argument on the motion?
I do. I would like to present the motion.
Okay.
May I use the
Please,
podium?
use the podium.
And Judge Slade and I have 5 copies of the motion, which I'd like to
Okay, fine.
take if I may.
That's not an exhibit. That's just courtesy.
Good evening, and thank you for allowing me to present this motion on behalf of the clients that Judge Slater just described. In this case, I drafted a motion to dismiss because there is no reason that this county board should subject itself and the public to a hearing when the petition so clearly violates your own ordinance 10-15-15. There are a variety of issues that are contained in the pleading I just handed you, and I'm going to highlight the most important one. It's an 18-page pleading, and I'd ask you to take a look at it when you get an opportunity to. But there are some major issues that need to be addressed immediately, and I'm going to ask the Zoning Board of Appeals to have a vote on whether or not to proceed with this hearing. First, the notice that was issued is wholly insufficient. The notice contained in Exhibit A, which described parcels where the special use is proposed. However, the description is of entire parcels of land. For example, parcel number 1 identifies the entire 118.44 acres of land owned by Roy and Grace Rogers. When you add up all of the parcels that are contained in this petition, it's 5,491.93 acres. That is the land that has been identified as the special use area that they are petitioning for. That completely violates the Illinois statutes. The county's code, 55 ILCS 5/5 12,009.5B requires that the particular location of the property for which the special use is requested be identified. They have not done so. They have not identified anywhere in this petition the specific locations of the turbines. The public has not been put on notice of what this proposed application even is. All they know is there's 5,500 acres that are apparently part of this proposal without being identified where the turbines are located. So the public doesn't know and cannot know how they are going to be impacted by this proposed use. Your ordinance explicitly requires that there be a site plan. It isn't contained in this material anywhere. There is no description of the property lines. You cannot tell where the turbines are going to be located, and this is completely premature for us to be here on a special use hearing. The notice is also improper because it must contain information on whether the petitioner or applicant is acting for himself or herself or as an agent, alter ego, or representative of a principal and the name and address of that principal. That language comes again directly from the Illinois statute of 12,009.5. In this case, nowhere in the petition does it identify whether or not Main Street or Green, what they're calling themselves today, Green River Wind Farm Phase 1 LLC is an agent, an owner, or what their relationship is to the actual parcels that are the subject of this petition. This is, again, in violation of the state statute that requires them to do so. Perhaps most importantly, though, is this application is complete and utter conflict with your proposed, your ordinance 10-15-15. As you all know, there's a proposed ordinance 10-19, which was not passed. Therefore, the current ordinance is 10-15-15. Subsection C of that explicitly provides, quote, applicant requirements. An application for a permit to build a wind energy system shall include the following. And there lists 9 things that must be included in an application. None of them are in this petition. The petition is a regurgitation of the proposed conditions of the applicant, which somewhat followed the 10-19 proposed ordinance, which wasn't passed. But it doesn't contain any specifics concerning the proposed application. Under 10-15-15, the ordinance that's actually you're operating under, they must, no discretion, must provide include the property lines of the proposed site of construction. Nowhere in this application are the property lines depicted in any manner of the proposed construction. They must include the proposed location of the WEX. Again, nowhere in the petition, and I've voided the petition from the county, nowhere in that petition is there a description of the proposed lines of the site of construction. That petition was filed May 19th. And 1 week ago, there still was nothing other than a description of what they would file. They said that at this hearing or before this hearing, they would file all of this material contained in 1 through 9. That is completely inconsistent. If they have, since June 28th, I think when I last checked, if they have filed something that I'm going to hear about, that's wholly improper. It was not contained in the petition. They can't be ambushing the public and the objectors with material as this proceeding moves forward. It was supposed to be contained in the application as required by their ordinance. And again, I'll repeat, it says application requirements. An application for permit to build an energy system shall include. That's non-discretionary language. The courts are very clear that when such language is used, it absolutely has to be followed. And that's the Al-Aboudi case versus Thompson and People versus Woodward. Well, in this case, again, number 2 under that ordinance is the proposed location of the wind energy conversion system. That is not contained in the petition that was filed. You cannot look at that petition and know where the turbines are going to be located. The location description of all structures located on the property where the WEX site is proposed. Again, no site plan was included in that petition filed in May. And there is no location description of all the structures on that property. Likewise, number 4, the location of all above ground utility lines within a radius equal to 2 miles, the height of the proposed WEX. There was no description of any above ground utility lines, let alone equal to 2 times the height of the proposed WEX. So again, that was not contained in the petition, it was not contained in the application. This petition must be dismissed, and it would be a complete waste of time to move forward. Likewise, number 5, they were supposed to provide the location of all underground utility lines on the property where the WEX site is proposed. Again, that was not contained in the petition filed in May and was not there a week ago, at least according to the FOIA responded to by the county. So 1 through 5 have clearly not been complied with and are not contained in the petition, which is an absolute mandatory requirement. And therefore, they haven't even met the prima facie requirements of an application. And therefore, you don't have to go any further than the face of this and dismiss this case for this application. Likewise, if you move on, well, one thing, they mentioned in their application that what they want to do is provide the exact number, location, make, or model of any proposed, they want to provide, after construction is complete, they want to provide as-built drawings showing the location of the WEX, turbines, roads, transmission lines, and related improvements. That's wholly improper. What's the purpose of having a public special use hearing if they're not going to provide the information about where the turbines are located, what turbines are going to be used, what the size of the turbines are, what the size of the rotors are, until after the hearing? It renders this entire process as an exercise of futility. If you move on to number 6, 7, 8, and 9 of your 10-15-15C ordinance, they will require to provide a dimensional representation of the structural components of the tower construction, including the base and footings. Nowhere in the petition that was filed is there a turbine selected. Is there a schematic of the turbine? Are there any, to use the language in your ordinance, dimensional representation of the structural components of the tower, or the base, or the footings? There's nothing there. I've been involved in many of these hearings, and this is the first time I've ever seen such an application where they don't identify at least an exemplar turbine, which I would argue is still improper. But to not even identify an example of one is ridiculous. You can't perform any analysis as to what the impacts are to neighboring properties if you don't know what turbines you're going to be using. Likewise, they were required under number 7 to provide a schematic of electrical systems associated with the WEX. That did not occur in the application as required. They were supposed to provide, at number 8, manufacturer specifications and installation and operation instructions for the WEX. That, again, did not occur. Finally, under section 9 of 10-15-15, they were supposed to provide a certification by a registered professional engineer that the tower's design is sufficient. They again proposed to do that after they get their special use permit. We'll get a certification before you give us a building permit, but not before we get a special use permit. That's not what your ordinance required. Your ordinance required them to have a certification when they walked in with the application in May. They didn't do so. The application has to be dismissed tonight. There are a variety of other grounds that I'm going to move through very quickly to start on page 7 of my motion. This project does not satisfy the blade clearance requirements, which is section 10-15-15B. Again, the petition does not identify what turbine you're going to use. Hence, they cannot comply with your blade clearance requirements because we don't know what turbine it is. We don't know how long the rotors are. We don't know how high the towers are. We know absolutely nothing about this proposal. Likewise, the project does not satisfy setback requirements. 10-15-15H requires the identification of certain setbacks, and they have not provided. The original petition did not have any map. Mr. Hinkle has informed me that they've now provided some type of preliminary map of potential turbine locations. However, that map does not depict the setbacks to easements, dedicated roadways, property lines, roadways, railroad right-of-ways, or electrical transmission or distribution line right-of-ways, let alone neighboring properties. Therefore, this preliminary map that was provided to me, which has absolutely no detail to it, just has dots where turbines may be located, and I was told that that wasn't even a final map, doesn't contain any setback analysis. There is no any setback chart in this petition, and therefore it violates 10-15-15H. The application states, and I'll quote, that they shall include a modeling analysis of the proposed site in the application, predicting the sound pressure in accordance with available best practices. But the application doesn't contain the very thing it says it's going to contain. There is no noise model in the application that was filed in May. So again, if they're showing up with it tonight, or if they have filed it in the last couple of days, that's wholly insufficient with your ordinances, and you're in violation of 10-15-15I. Likewise, 10-15-1 has requirements if there's going to be exterior lighting on a proposed use. And require the applicant to identify evidence that the proposed work will comply with the lighting requirements, and they have failed to do so. There's no discussion of the lighting elements or what the candle feet will be concerning the lighting. Therefore, it is a violation of 10-15-1J. Likewise, there's no discussion of vibration as required by 10-15-2. Again, they can't do so because they didn't pick a turbine. They can't discuss what the vibration would be to the neighboring uses because we don't know where the turbines are going to be located. We don't know what the turbine size is. We don't know what the rotor size is. We know absolutely nothing about the proposal. Likewise, 10-15-6 required there to be some analysis and discussion of the electromagnetic radiation and provides unlawful to operate a source which does not comply with the current regulations of the FCC concerning electromagnetic radiation. There's absolutely no discussion of the impacts of these turbines, whatever they may be, and no analysis of the neighboring uses, no studies, no tests, etc., of whether or not there's going to be an impact on transmissions nearby. Likewise, 10-15-8 prohibits any direct or sky-reflected glare so as to be visible at the lot line of subject property. The applicant makes mention of glare, but provides no studies, tests, data, or information in the petition whatsoever that would address anticipated glare from the turbine. You'll also notice that, and this gets back to the notice issue, certain turbines are identified as appearing on multiple tracks. For example, turbine 56, 68, and 82 are identified as appearing on 2 different tracks, many of which are 100+ acres in size. So again, there's no way that one can read this application and know where the turbines are being proposed. As a more elementary exercise, this application should also be denied because it simply isn't appropriate for a special use. The courts have determined that the purpose of a special use permit is to provide for infrequent types of land use, which may be incompatible with uses usually permitted in residential, commercial, and industrial zones. The special use permit allows for a use that otherwise might be prohibited in certain zones where the adverse effect on the surrounding area is not too great. That's the Miller versus Hill case, the Cook County versus Monette case. The intent of the special use, therefore, is to allow for one infrequent use on a single property that does not affect a great number of other properties. The purpose is not to permit an applicant to impose the effects of an indeterminate number of 500 or 600 foot turbines, you don't know how tall they're going to be, over 5,500 acres. That is not the purpose of a special use permit. A special use permit is an exception to the permitted uses that is allowable because it's an infrequent use. It does not dominate the neighborhood. How in the world can a 5,500 acre proposal be appropriate for a special use? It cannot. So, in conclusion, I'm asking the Zoning Board of Appeals to vote on whether or not to proceed at all with this petition. The petition violates the notice requirements of the state statute. And more importantly, it violates 10-15-15 because it doesn't have any of the 9 required elements of a petition for special use for wind energy conversion system ordinance. I hope that you will entertain that motion and grant my motion to dismiss this petition this evening. Thank you.
Thank you, Mr. Porter. Mr. Lee, would you like to respond on behalf of the applicant?
Thank you, Your Honor. Good evening. I think most of you know my name is Doug Lee. I represent the applicant Green River in this matter. Strikes me as a little ironic, perhaps, to be accused of ambushing the board with this application. We were just given this 18-page motion to dismiss about 10 minutes ago. So I hope you'll forgive me if I'm not prepared to respond to it line by line or paragraph by paragraph. But I think Mr. Porter was correct about one thing, and that is that there are basically 2 issues in his motion. One is the notice requirement. And in his overall concern regarding the notice requirement is that the applicant has not identified the particular sites of where the turbines will be. Those of you who've been involved in this before know that that's how Lee County has handled this in the past. There's been no requirement that applicants at this stage of the proceeding bring in site plans that show particular places for where the turbines are going to be. And that's not because of a desire to ambush anybody. That's because of the economic realities of the development of a project like this. Now, these projects are developed after a permit is obtained. Then the developer goes to market to find out what turbines are available and what they're going to cost. the developer then, once he knows what kind of turbines he can obtain, lays those out based on the varying heights, the setbacks that the zoning board is required and the county is required, and then proceeds to work with the zoning officer to develop the specific site plans, get the building permits, etc. That's how it's always been done. That's how this was done. The other point that Mr. Porter makes about the notice requirement is he says that we haven't identified who the application is on behalf of or who the petitioner is acting for. Well, it says right in the notice that the petitioner is acting for itself. So I don't know what more is thought to be needed regarding that. The other point Mr. Porter makes is this reliance on 10.15.15c. And then the 9 points that he alleges are required to be contained in the application. And he read it to you, but he read over some of the key words maybe a little more quickly than I would. What Section C says is an application for a permit to build a wind energy system shall include the following, 1 through 9. As this county has traditionally interpreted that provision, that's what the applicant needs to show to get the final building permit. If there's any doubt about that, read Section B, permits required. A building permit shall be obtained to allow construction of a wetlands. If the special use permit is granted, there's no doubt the developer will come back to the zoning officer with an application for a building permit that will include all of these 9 items. That's how it's always been in Lee County. The ordinance hasn't changed. You all are very well aware of that. This is consistent with what's been done in the past. There are other points made in the motion that Mr. Porter has mentioned, but again, he highlighted the 2 that go to whether the application is deficient on its face. Assuming that this hearing proceeds, the applicant will introduce considerable evidence of all of the issues, all of the facts relevant for this board to consider what to recommend to the county board. It's very premature, we believe, to require the applicant to provide all of that information in the petition itself. You have before you tonight books that we're calling the application that have further information in those. The witnesses will provide additional information. We'll have expert witnesses that will provide reports that are not yet finalized and provided. No one will be ambushed. Everyone will have ample time to review those documents and those reports. The issue before you, seems to me, is whether you're going to allow the hearing to proceed. And we submit that the objectors have not provided any basis for you to somehow dismiss or deny the petition outright. Thank you.
Thank you, Mr. Lee. Mr. Chairman, the former judge made the instinct there is to make a ruling on the motion, but as you know, I'm not engaged to make rulings on motions. The final decisions are up to you. I'm here to make rulings on procedural and evidentiary matters, and that's it. I'm also not allowed to, nor should I give you legal advice. You may take the motion from here. You may want to take counsel of your attorney, Mr. Dixon. I will leave that to you, however. So let's dispose of the motion or in some fashion, and then we'll proceed with chronology.
Based on our testimony we just heard,
Well, just a minute. You haven't heard any testimony, and if you want to counsel with Mr. Dixon, I encourage you to do so.
okay. We'll ask Mr. Dixon, you want to come forward? Is there any questions on the board?
I assume you'd like me to come over there
Yes.
so I don't talk loud enough.
Yes.
I have a question for Mr. For the record, my name is Henry Dixon. I'm the Lee County of Chris Hinkle just a moment ago, whether Mr. Porter filed an appearance in this proceeding. He advises me that Mr. Porter did so.
He did, and it's marked as Exhibit 3.
Unfortunately, I was not privy. I did not get a copy of that. I'm not part of the Zoning Board of Appeals. I'm merely the attorney. I have 2 points to make. The first is that when it comes to armed combat against an enemy, defense by ambush is a very valid procedure. When it comes to legal matters, defense by ambush is not a very legitimate procedure. I received a copy of an 18-page, really 17.5-quarter-page document containing allegations of fact, representations of law. And I received that perhaps 10 minutes before you began the proceeding. I've had several minutes more than 5 of you have had to look at it. My view is that in this respect, you should defer any determination with respect to either the validity or the merit of this motion or petition until the end of this proceeding. Not the end of tonight, tonight's 2.5 hours, but the end of the proceeding. Secondly, as I indicated, this is an issue of mixed law, a matter involving issues of mixed issues of law. In fact, that's contained in this petition. So you have to determine the validity of the representations as to the law cited in the document seeking immediate dismissal. And also, there are allegations of fact, and you have to determine whether those fact allegations have a basis in fact. I don't think that you're able to make that determination at this time. Consequently, for both reasons, I would give you my advice that you should defer any determination on Mr. Porter's petition, Mr. Porter's client's petition, until the end of this proceeding. Thank you. Do you have any questions?
It seems like the biggest concern would be the notification of the public meeting. Has it been properly, has the public been properly notified?
I think so, but I don't know that as a fact. I think that's a fact matter that has to be developed by some form of hearing. And that's why I don't think that this petition to dismiss should be one that you should undertake at this time to either to confirm it or reject it. Anything else?
On the legal precedents now, Henry, what I'm thinking is maybe we didn't do all the other work right.
Or maybe you did, and somebody else just perhaps didn't.
But, I mean, we have to do this one legally because there's going to be all kinds of holes that people are going to crawl through.
Sure.
But, I mean, as far as legal fees, I think there's some merit here, don't you think?
Have you read it? I haven't. I've only got
Well,
to
I
the
mean,
first 7 pages.
the points that Mr. Porter made is we just assume, or we don't know what kind of windmills they're putting out. These things could be 800-foot tall windmills. And, you know, I mean, it would be nice to know before we go through this whole process and have an idea.
My intent is to determine all that before we go. And then we're going to write what we'll allow them to do.
But it says here, Mike is supposed to be in the petition.
So that's what I'm asking Henry, was the public notified sufficiently enough to continue to find out from that? That's what
Well, you know,
I don't know.
Mr. Chair, I think you need a motion some time so you can continue a discussion, so you can focus on the discussion. I don't want to interrupt your discussion, but I think somebody needs to make a motion on the second.
Someone here to make a motion one way or the other on this petition. Well, we can vote in way after. Well, I make a motion we approve Mr. Porter's petition. Is there a second? If it dies for lack of second, then we're not open for discussion. If it dies for lack of second, then we're in discussion.
That's correct.
Okay, if it dies for lack of second.
You still need a motion to dispose of the petition.
You can still make a motion.
My view is, yes, you can. We make a valid motion, and we will affirmatively ask you to use it.
Yeah, but I guess I'll make a motion to defer, but no time.
Second.
I'll second.
Second by Bruce. Okay, any more discussion on the site? Well, I think there's validity to it. I mean, I just don't think that we could, I mean, Greg, you gotta do everything legal. This keeps it open. All right,
Chris. 10-15-15, we don't have that, and we need that. I don't know what he's focused on. That's the old ordinance?
That's the old ordinance, the one that's been in.
Excuse me for interrupting, I do have copies of it.
yeah, that's more than how many years do you think, 10?
Probably.
Okay, so this motion's been made to just look it on the table. Defer it. And any other questions that can be brought back up at any point. Discussion or whatever action I take. Any points out, we go over. All those in favor, any other questions? If not, all those in favor of deferring this to the time being, say aye. Aye. Opposed, same sign. Aye. None opposed. Motion carries. Turn it back over.
All right, thank you. Now, ladies and gentlemen, we'll begin with the chronology, the procedure outlined in the board's rules. Is Mr. Lee, you may present evidence. May we begin? Open statement, I'm sorry. Absent parties, open statement.
I have an hour-long opening statement I didn't want to get cheated out of. So. Just kidding. Thank you, Judge, and members of the zoning board for your participation in this hearing. As I mentioned before, my name is Doug Lee. I'm here with Gary Gelbach, and we're representing Green River with this petition. With us from Green River are John Martin, Matt Boss, Steve Olin, and Chris Dorman. Gary and I are privileged to represent Green River in this proceeding and make this presentation in support of the petition for special use permit. Green River, I think, is equally proud of this application and looks forward to presenting it and answering your questions. There are really only 2 points I want to make in this opening statement. First, this project will bring significant economic development to Lee County. And
I can't hear him.
Sorry.
Microphone on, please.
Sorry. First, this project will bring significant economic development to Lee County. And it's the best kind of economic development because it's a significant investment in the community that doesn't strain or estimate is $160 million. Hundreds of local construction jobs. When completed, the project over its first 20 years will generate local real estate taxes in Lee County of approximately $15 million. Second point I want to make is that this proposal is more protective of Lee County residents than any other wind farm Lee County has approved. Therefore, while you have to remember that there's no economic development, no growth that's impact-free, you will hear and see evidence that Green River has taken several steps and is proactively proposing conditions to minimize the impact of the proposal on the residents of Lee County. Now, we've already seen how this is going to go. Green River has been through a hearing and evidentiary hearing in Whiteside County. The Bureau County proceeding is ongoing. So we're not under any delusion that this hearing will be quick or without objection. We're confident, though, that after you've heard all the evidence, you'll find that Green River has complied with the existing ordinance, proposed conditions more restrictive than any other condition the county has required, and taken reasonable steps to minimize the project's impact. Therefore, at the conclusion of the hearing, we'll respectfully request that you recommend that the Lee County Board approve the petition. Thank you.
Thank you, Mr. Lee. Now you may begin to present your evidence.
This witness calls John Martin.
Raise your right hand, Mr. Ryan. You solemnly swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth.
I do. Mr. Martin, would you state your name for the record, please?
John Martin.
And how are you employed?
I am Senior Project Development Manager with Mainstream Renewable Power.
And you prepared a PowerPoint presentation?
I did.
Would you like to present that to the zoning board?
Absolutely. Appreciate everybody's time this evening. It's good to be in the cool atmosphere of this room again. Wanted to go through some of our PowerPoint presentation with some of the project specifics. Similar to Mr. Lee represented earlier, we will be providing other expert testimony. So to that end, there will be more content presented later. Again, we're here to present our petition for the special use for Green River Wind Farm Phase 1. Next slide, please.
For the record, exhibit number 2 I've been tendered purports to be screenshots of the PowerPoint you're about to present. Is that correct, Mr. Martin?
That's correct. In fact, maybe even prior to that, we should address number 1, exhibit number 1, which is the big book of materials, which is supplemental information to the petition itself.
I object. The application was supposed to be filed before the public hearing in May. I've not been tendered any supplemental materials, and this is exactly what I was talking about in the motion to dismiss. This is an application by ambush. I'm assuming that now contains some substance that was not present in the original application. It has not been provided to the public, it has not been provided to council. I have interference in this matter, it's ever been given to me.
Thank you, Mr. Porter. Any response, Mr. Lee?
And I believe we have a copy.
Sure. We have multiple copies. Matter, Chris.
Response from Mr. Lee.
Yeah, well, we're happy to provide a copy.
Under the board's rules, there are no time parameters. The exhibit number 1 has been tendered tonight. It will be admitted.
Okay. So again, much of the information I'll cover.
If I may, for the record, I've been handed a document that is no less than 3 inches in depth. And the original petition was a mere 20-some-odd pages.
You may proceed, Mr. Martin.
Much of that content is covered in more detail in that document. Next slide. In selecting a site for investment for a wind farm, Mainstream and many other companies go through similar steps. We're looking for proximity to grid lines, such as we have kind of running north to south, in the Bureau and Whiteside area. We're looking for access to off-take power markets, such as
I have to object again. The procedures allow for a continuance based on good faith basis. I am asking that this hearing be continued at a minimum so that the public and I and my experts can have the opportunity to review the application before having to conduct cross-examination on the application. It is at the minimum that due process is required.
Response, please.
I guess I would suggest that be deferred until Mr. Martin concludes his direct testimony. At that point, Mr. Porter believes he needs additional time to prepare cross, and that would be up to the zoning board.
Again, I point out that the board's rules allow the admission of written material at any time during the hearing process. This does not violate the board's own rules. The rule is admitted.
with respect to the access to off-take power markets. These grid lines access the PJM market, which largely runs from Illinois eastward, allowing a decent amount of off-take options for projects such as this to sell power. With respect to the land we're looking for open land, we're looking for statistics on population density. Once we start our leasing land efforts, we're looking for supportive leased land. We have an excess of 13,000 acres leased in this area for the project. Not all of that will be used, but that's in addition to that will be the collection lines, which would be some of the transmission lines underground between turbines on other leased lands. We are also looking for reasonable government regulations, such as Lee County has considered and ultimately voted down. Some of those regulations are very reasonable, and we tried to represent what we felt was appropriate in our application. With respect to, obviously, we're here for a wind farm, and we're looking for a strong wind regime. There is as obviously represented by the wind farms that are in Lee County, currently there is a robust wind regime, and Lee County has seen the benefits of hosting those wind farms firsthand. Another thing with respect to the planning, with respect to a county planning effort, we look to see if the county has a comprehensive plan, and Lee County does have a comprehensive plan, and we've looked at that, and we feel that we fit with the selection of our site. A little history on the project. Mainstream acquired the project from FPC. Formerly, it was under the moniker of GSG2 back in June of 2009. We then started our land campaign of signing up leased properties in August of 2009. The project specific, it covers 3 counties and 4 townships, so Whiteside, Bureau, and Lee counties. And we cover Greenville, Hanneman, Hamilton, and East Grove townships in terms of what land it would touch. Again, we have an excess of 13,000 acres signed, and in addition, we would have the collection line. The project itself is proposed for the grid injection of 212 megawatts of capacity. That would be the upper limit of the total size of the project. So depending on the turbine model and the number of turbines, that would be upwards of 212 megawatts. Our wind measurement campaign, which is obviously an important aspect of developing a wind farm, started with a 60-meter Met tower back in March of 2010. In May of 2011, we installed a 100-meter Met tower, and we supplemented that Met tower with some SODAR units, which are roving SODAR units to make sure that we have coverage on all the aspects of the wind regime. We also completed grid studies in June of 2011 and supplemented and additionally signed an agreement with PJM, and technically I guess with ComEd, since they are the owners of the line. PJM manages them with respect to our 212 megawatt proposed project. We started environmental studies back in October of 2009, and some of those are even ongoing, as I'll outline later, and as will my experts. local outreach is important to us. We had our first meeting in January of 2010, and we've had many since. With respect to zoning compliance, I know most of you just by spending 18 months together, Mr. Forrester, we haven't met, but we've been on top of what's going on with each of the counties with respect to their zoning, and very much want to play a part in that as much as we can. A little information about Mainstream. So Mainstream is a global company based in Dublin, Ireland. Our U.S. headquarters are here in Chicago. Green River Wind Farm Phase 1 LLC is a wholly owned subsidiary of Mainstream. This slide gives you a little bit of details about the markets we're in and some of the capacity, the development capacity that we're pursuing. I think the bottom left statistic, the 5,700 statistics of megawatts, is now 6,500 megawatts of capacity, if I'm not mistaken, so I apologize for that being outdated. We're also pursuing solar projects globally as well. And with respect to the U.S. projects, we have projects in California, Ohio, and then obviously here in Illinois. A little difficult for the audience to see, but on yours, it'll show a thicker blue line, which is effectively our overall project map. We do not have all the lands leased within this area, but it effectively follows our leased lands and the project layout with respect to those leased lands. So this is the Lee County portion of the Green River Wind Farm. Again, we have leased lands in Hamilton Township and East Grove Township. We are, as Mr. Porter stated, leasing and proposing approximately 5,500 acres for special use conditions, or for special use decision. And again, this is effectively follows the lease lands that we have that are detailed in the project itself. The next two slides are a breakout of something you'll find in the petition, something you'll find in the application booklet that we provided. It's detail on each of the landowner entities and the PINs. And again, we're asking for special uses on each of these parcels. There you go. So, permitting specifics. We're now here kind of back to the drawing board in terms of the ordinance that exists here in Lee County. And what we understand is that we've had the ordinance. There's certainly precedence to the special conditions that came for the built projects beyond that ordinance. Then there were your supplemental ZBA recommendations, which 4 of you were very involved in. And then there's obviously the permit conditions and stipulations that could come with any application. And we've proposed some of those ourselves. We were present and participated in all the discussions about the new zoning ordinance. For whatever reason, the board chose not to adopt it. During the discussions, we learned a lot about the items that are important to the ZBA and the residents of Lee County. We've therefore addressed a number of those items in our petition. And we're willing to agree that they can be conditions on the permits we're requesting. Overall, though, we believe that the project, as proposed, is good for us and for Lee County. And we note that if the project is approved, it will offer considerably more protection for Lee County residents than the other wind projects the board has approved thus far. Next slide. I believe Mr. Porter was concerned about setbacks. Again, the existing ordinance effectively only has 3 setbacks, all the same of 350 feet from the property line, a public road, or third-party transmission line. I think there is precedent of 1,400 feet from homes. In addition to that, possibly 1.1 times the height of a turbine from a property line. We're proposing to go with what 4 of you recommended to the county board, which is 3.5 times the height of a turbine, or 1,400 feet, whichever is greater. With the turbines that are largely available today for this type of wind regime, it's going to be in excess of 1,400 feet. So what we presented is the Siemens 2.3-113 model, which is a 512-foot turbine, and the Siemens 2.3-101 turbine, which is a 492-foot total height turbine. And you can see the math on what that means in terms of setbacks here with respect to 3.5 times the height or 1.1 times the height from the different entities or different aspects that you wish to have setbacks. Regarding turbine layout and flexibility, again, Mr. Lee addressed this. To date, Lee County has existing projects that have basically followed a model of permitting the parcel. With respect to your recommendations, we realize that there are further considerations to be had with some details and models that we're providing. There are a good amount of things that change with respect to the location when you introduce a different type of turbine. It could be a setback based on total height. It could be a sound characteristic. It could be an efficiency item with respect to the layout. So there are many engineering challenges that come with the turbine layout and the flexibility thereof. But as Mr. Lee addressed, it's equally as important, if not more, regarding PPA opportunities. And the PPA is the power purchase agreement. That's an agreement that we would sign with a company or with an entity in order to take off the power from our project. It's a very competitive world to obtain those PPAs. And turbine pricing is changing consistently. So we wish to retain the flexibility that you've had here in Lee County with respect to selecting a new model, a different model as modeled with some of the analyses we've done today. So I outlined here what I would call effectively our permitting process, our proposed permitting process, and that is basically, as with all the other projects, we're seeking to permit the parcel, not the specific site. The proposed sites are the sites we'd use if we use the two Siemens models. After the permits are received, we'll go to market and select the turbines. If we select different turbines, those selections likely will result in changes to the identified locations. Some of those changes could only be a few feet, others could be much farther. Some might even result in use of more turbines within the permitted parcel. In every instance, though, projections for Lee County residents will remain the same. We'll be bound by the required setbacks, the noise limits, the commitments to shadow flicker, mitigation, and decommissioning. Further, any changes we propose will need to be approved by the zoning administrator. If he needs resources to hire consultants to ensure compliance with the requirements, we'll provide the financial resources so that the county can retain the independent consultants of its choice.
Mr. Hearing Officer, is there a copy of this PowerPoint?
Yes, it's marked Exhibit 2. At least the screenshots are.
Yeah, there's some. I don't want to take Again, the reason why we outline this proposed permitting process is important for the county to understand that permitting is a key step towards actual construction. It's very difficult, if not impossible, to procure turbines or make final project decisions until projects are permitted. Turbine pricing and project performance will play a good part of it. Next slide, please. a little difficult to read from the audience, I'm sure. These are 18 models of turbines that are available at this point that may fit the profile for a project. There may be other ones to come on the market, but these are the ones that we've chosen to provide more specifics on in our application book. Again, these are the commercially available ones. You can see where they range in height, they range in megawatt capacity, those types of considerations. Next slide, please. With respect to the technical studies we've done to date, we will have provided a market analysis, a wildlife. There's a lot of wildlife material in our application book. Sound assessment and shadow flicker analyses. Those will also be provided. These are the areas where we feel that expert testimony could supplement our application. So we plan on bringing these experts in. I do want to make a statement with respect to the wildlife. With the recommendation letter that came to the county regarding the Foley Sand Prairie area, we are taking that recommendation and heeding it. It's a mile setback from Foley Sand Prairie, which is I believe it's a 22-acre parcel in the north, in this part of our project, the northwest part of our project. So, and we continue to have consultation with the IDNR with respect to some of those aspects. So, one of the items in your proposed February application, or your proposed petition, text amendment to the ordinance, we felt was unfair and unworkable. So rather than put everyone through the home seller protection program that we feel is unworkable and rife with conflict, we prefer to provide some further direct investment in this community. And this is something it depends, it's project by project item, and it depends on the stipulations that come with the project, but it's a good neighbor agreement. And typically, these are significant investments, and they're kept local, rather than just someone to take the money and leave. We propose that the good neighbor agreement that we put in place with a homeowner would run with their house, stay there for whoever owned it. It would be for homes that exist at this time of the application, and that the criteria that we are looking for is more than 11 hours or more per year of conservatively modeled shadow flicker. In exchange for us allowing, or for a homeowner allowing us to cast that much shadow, we'd be willing to offer $1,000 per year for the 20 years, including an escalator of 2% or CPI, whichever is greater. And but that would require an opt-in to this program. We are offering the same agreement project-wide. And again, depending on what comes out of these proceedings, this is our plan for a good neighbor agreement at this point. Other technical studies that have been performed in the application book that you have is the TV reception baseline. So we effectively canvassed the area, our experts canvassed the area and measured the current conditions. And we realized that as a result of changes to those conditions, adverse results of changes to those conditions, we're obligated for those direct impacts. And we're willing to accept that. We also did a communication analysis and microwave beam study looking at different emergency communications, different microwave beam communications, and that analysis is provided as well. The soil and water report, I believe the county is currently wrapping that up with respect to the soil and water report, and the Army Corps of Engineers has approved the project for its wetlands permits. I believe there's Section 6 and Section 8 permits. We can provide those copies if necessary. And then with respect to the floodplain, what you see here on this map, and the colored map in front of you, the hashed blue lines are the projected FEMA 500-year or 100-year floodplain. And so the county obviously had concerns about building in that floodplain, as did the IDNR. And we've gone through some significant studies and gotten approval from the IDNR and outlined our plan for the county with respect to building in the floodplain. Additional development activities have been ongoing, and some continue to be ongoing, are the FAA, the Federal Aviation Administration. We submitted 512-foot locations, again, that tallest model in our application here, throughout the project area, and we received determinations of no hazard. With respect to fire safety, we've been in contact with the appropriate departments and the fire protection districts for the project area. Mr. Anderson and I have directly discussed a draft agreement of the road agreement that he has been reviewing, and those discussions are ongoing. As well as that will cover, and we've been in communication with each of the township road commissioners regarding the steps that need to be taken in establishing it. East Grove in particular has already been through the Big Sky Wind Farm. They understand what their likes and dislikes in terms of the road agreement will entail. Engineering is an ongoing effort. We've had geotechnical efforts done in the field, 2 rounds of that so far. We've had a variety of layout considerations, both as the setbacks change in these different counties, as well as other considerations with respect to the layout. So we also are consistently looking at our collection systems, which again is the underground collection between the turbines of the electricity before we step it up at a substation. Hazardous waste, we realize that the ordinance requirement during construction as well as post-construction and operation, we realize that there's a hazardous waste disposal and management that we plan on covering. With respect to drainage districts have absolutely need to be consulted with and in agreement with what we're working on here. Green River itself is effectively created, so I understand, to drain a lot of this area, and so we need to consider that. We also, though, it's important to note that it comes up in a lot of proceedings, is we have direct landowner obligations in our lease regarding the protection and repair of drain tiles. We want to make this board as well as our landowners comfortable that those will be covered properly. Many of the ordinance provisions, of the proposed ordinance provisions, included operational compliance items. We believe that our application speaks to those, and we're well aware of them. And then decommissioning. We've proposed a decommissioning plan to Whiteside County. That I believe a copy of that has been tendered to Chris Henkel. It's effectively the same plan we would propose here with some of the quantities changing. But what we feel is most appropriate here with respect to decommissioning, and this is effectively what came out of the hearings, and maybe most notably the ad hoc hearing subsequent or prior to the board vote on the proposed ordinance, was that the county wanted the change to the benefit of the landowner rather than the county for the money in the decommissioning funds, and that it be held with a third-party escrow. So that was the plan for that decommissioning is effectively created or required to be in place prior to the building permit for our ordinance or for our petition. So that's where we stand on the decommissioning plan. That's effectively all I have this evening. I think again, I know there's more content to be provided by our experts in some of these areas. So we look forward to any questions you have. Thank you.
Mr. Martin, I've got just one. The one item you didn't address. You heard me in my opening statement refer to the economic benefits of this program. Did I describe those accurately?
Yeah, I believe your estimate on the total investment was was low, but it'll depend on total number of turbines. Some of this is somewhat of a moving target, depending on quantity and projections, but the magnitude of them are absolutely correct.
Well, I object to the strike. He hasn't testified to anything. He's trying to create counsel's statements into testimony improper, restricted.
Overruled. Mr. Martin, you want to have a seat up here, please? All right. First, members of the zoning board. Questions of Mr. Martin? Mr. Burrow. Mr. and if I mispronounce names, I apologize. Mr. Bothing or Both? Question? Mr. Fassler?
Not at this present time.
Mr. Pratt?
Well, I don't know what I'm supposed to ask here, but
Well, just the time for questions.
my objective here is you talk about taking location and then redefining at a later point. That's not where I want to end up.
That's not a question, Mr. Pratt. Just questions. Cross-examination.
You're a good neighbor agreement. Is that negotiable?
At this point, no, because we don't know what the end-all conditions of the permit is at this point, no.
Not negotiable to any homeowner. It's a blanket policy. Every homeowner will do the same.
That's the blanket policy of this point, yeah. We're willing to consider other mitigation steps such as blinds and tree stands and that sort of thing, but it's effectively on a case-by-case basis.
So where does 11 hours?
We're going to provide the Siemens 2.3 and 101, or 113 and 101 shadow flicker analyses and have the experts testify to them, and it'll be modeled and conservatively modeled in those assessments.
How are you able to determine which house would have 11 hours if you don't know the location of the?
So there's a layout provided today, and many of the site plans that are in Exhibit A of the book for the Siemens 2.3 113, and that will speak to a specific layout for that model that would be accompanied with analyses appropriate for that. If we change a model at a later date, we realize that the ZBA wanted these analyses done up front, so we expect that prior to building permits, or we hope that prior to building permits, we would be able to supplement the application with those additional analyses in the same method that we will have at this proceeding.
I can't hear you, sir.
No further questions.
Mr. Forster?
No question.
Thank you. Now, interested party, Mr. Porter, questions?
Yes, I have quite a few. May I take council's table, please?
The table or the podium, it's entirely up to you.
I need some room. Mr. Martin, the petition is brought on behalf of a company called Green River Wind Farm Phase 1 LLC, a Delaware limited liability company. How many wind farms has that company built?
None.
What assets does that company have?
Technically, I believe none. We hold the leases.
What does LLC Does that LLC have any grid interconnection rights?
Yes, I believe it does.
Does that LLC have any power purchase agreements in relation to this project?
It does not.
You mentioned projects of Mainstream in the United States, and you said, of course, Illinois. What projects does Mainstream run in Illinois presently?
We do not operate any projects in Illinois.
So you stated earlier it was erroneous?
Absolutely not. We have projects in development in Illinois.
This project, correct?
This project, potentially a second phase of this project, as well as some other ones.
Where will the second phase of this project be?
That's to be determined.
Well, you've already determined that there's going to be a second phase, apparently. Where is it going to be?
Projects aren't necessarily developed purely around the geographic focus. Sometimes they include aspects such as grid agreements, those sorts of things.
Okay. Where is the project intended to be?
Again, it's specifically to be determined, but we anticipate a Green River Wind Farm Phase 1 and Green River Wind Farm Phase 2 being in somewhat close proximity to each other in kind of the three-county area, Whiteside, Lee, or Bureau.
You mentioned that you have projects in California and Ohio. What projects?
We have a few projects that I'm not specifically familiar with in Ohio. We actually have 2 projects in development there, but those are not in my purview. Illinois is my suite of projects.
Now, you guys had a PowerPoint, and we put that PowerPoint back up, please. And it had a slide on maximum information, and then the blue areas are areas where you have apparently projects, and you've got the entire U.S. blocked off. But Ohio, there is no project presently running, is that correct?
That's correct.
In Illinois, there's no project presently running, is that correct?
That we operate, no, but we took part in the Shady Oaks project here in Lee County.
In California, do you have any projects that are actually running?
No, we do not.
So you actually have no operating projects, correct?
That's correct.
So why did you tell the panel of what?
I don't believe I said operating. I believe I said that we have projects. And so when referring to projects, I'm referring to either operating or in development, not development type.
Does Mainstream have any actual experience with onshore wind turbine projects?
Absolutely.
Where?
Again, you missed the point about Shady Oaks here in Lee County. I believe we have projects that are under construction in South Africa at this point, as well as others in, I believe Chile is under construction at this point.
You keep mentioning Shady Oaks. Mainstream didn't develop Shady Oaks, correct?
I believe it was probably GSG, I forget the number, but GSG 6.
All right. Look, you're under oath. Let's not get testimony from somebody sitting behind you. If you don't know the answer to a question, you say don't know.
Understood. I believe Shady Oaks was operated under a GSG entity, specifically which one I'm not aware.
What is GSG?
I don't know.
Okay. So Mainstream has actually never developed a project in the United States, correct?
The entity itself or its wholly owned subsidiary?
Any of them all?
Actually, yes. So, again,
What project has Mainstream developed in the United States? It's up and running.
I don't want to speak to Shady Oaks being fully commissioned and operating at this point. I'm not sure. Otherwise, there would be none.
Now, the application that I acquired by request to this county is actually only the first approximately 27 pages of this orange binder that's been handed to me today. But this orange binder is dated May 14, 2012. Was all of the material submitted to the county on May 14, 2012?
No, it was not.
When was all of this additional material that was handed to me for the first time this evening provided to the county?
Today, you elected.
Now, I reviewed the actual petition that was filed on May 14, 2012. And would you agree that that petition does not include a depiction or description of the property lines of the proposed site of the construction?
I would agree that there was not a plan provided, yes.
Now, to date, have the property lines of the proposed site of the construction been provided?
Yes, I believe the property lines of each of those is Exhibit A of the book provided today.
Okay, the property lines of each of what?
Each of the parcels on which the construction would occur.
All right, I'll just grab the first one. And again, I haven't had the luxury of seeing these documents before this evening. And it appears that there's a key to the first document on Exhibit A, referenced, and it shows a small gray line as property line. If you would, show for me on this first exhibit, the first one I grabbed, the geometric shape that depicts the property line of the parcel that is identified as land use permit T27.
I think it's more important that you focus on that.
Well, I don't care what you think is more important. Right now, I want you to identify for me what the parcel is, the geometric shape that depicts the property line, and therefore the parcel that relates to land use permit T27.
It would be the thick maroon lines, also identified in the key as West property.
Okay, the thick maroon lines do not complete the geometric shape, however, isn't that right?
Actually, I believe they do. They are all on the page, and they can be distinguished between the pin next to it, the pin being the property index number to the east, north, south, and west.
All right. We'll have to check this later again because this is being handed to everybody today for the first time. What parcel in the petition does this relate to? And I direct your attention to the parcel numbers which start on page 1 of that petition.
You can find the parcel number identified in the and labeled by the landowner initials. Which one are you looking at, T27?
Right now, I'm looking at the very first one in your binder, and I want you to tell me what parcel that is as it relates to the petition.
T27 is the parcel labeled 193040002.
Well, they have parcel number
6.
Parcel number 6. Now, are you indicating that this diagram as drafted, let's break that. Where's the legal description for parcel number 6?
Provided in the back of the petition, it's the front of this book.
Okay. Are you testifying that the area that has, it looks like a crisscross pattern in it, is the same as the legal description identified as parcel 6?
Not solely the crisscross pattern, it would be bounded by all lines around the D and S Magnuson with the subsequent PIN number.
All lines for the D&S Magnuson. What do you mean by that?
All the maroon lines around the D and S Magnuson effectively encompass that parcel. So the reason I say that about the hatching is it also, I believe that also talks to some of the floodplain area, so that also goes over to the D Renner property. I don't want you to be confused by the hatching as much as the center of the drawing.
If you would, just show us the geometric shape that is the property, legal property description.
I'm happy to call this up on the plan. You might need to help with planning here. We're going to try to find a file so that we can fill out graphically for everybody here. But again, it's the, I suppose it's almost a trapezoidal plan in the center to middle part of the page, or center to eastern part of the page.
Well, there are a variety of thick maroon lines on this document, such that I'm having difficulty, having read this before, in determining which one is the WEX property line for parcel 6. So I would need your assistance in showing me exactly which one it is.
Again,
Which one what is it? Can you be a little more specific?
Well, the diagram has maroon lines crossing the center of the page, at the top of the page, crossing several locations throughout the page. Where is the property line? That's what's supposed to be depicted in the application.
so again, there's many items on this page to help you find that, Mr. Porter, including
If you would just show it to me, we'd get there quicker.
I'm happy to walk over that for you for each and every one of these.
at least one, so I can see what you're talking about.
At this point, because the decision maker is the Board of Appeals, we're going to have to ask both of you guys to go over to the front of them. And
Parcel 6. Parcel 6. Shirley Magnuson. This in Lee County in the section Township Range, bounded by these blue lines. Labeled within the property line section as a west property. There are other ones that are shown through the scale of this, but that is the property for parcel 6.
Okay, so each page may have other properties depicted on it, in addition to whichever one you're referring to as far as the Wex is concerned, is that right?
That's correct. The Wex, 8 Wex is provided in the center of the page to indicate on the site plan with respect to that parcel.
Okay, and regardless, none of the property lines were depicted in the original petition, correct?
That's correct.
Now, if you would turn your attention to turbine 56 for me. And let's start with the actual petition. Which parcel is turbine 56 supposedly going to be located upon?
I believe I know where you're going with this question, and I'm happy to answer them one by one, but it is projected for M. Bhutan. It would be the 19141000002. Let me get back to the petition to double check. But I know that you're asking about some of the mislabeling they had in terms of turbine numbers. And again, the parcels are correct. We doubled up on some projected turbine numbers for the Siemens 113 layout.
Okay. Turbine 56 is identified as occurring in parcel 14 and in parcel 30, right?
That's correct.
Okay, and now today we've come up with some diagrams. Where is turbine 56 depicted in your diagram?
Parcel 30.
So it's not at all anymore in parcel 14?
That's correct.
Okay. And in relation to turbine 68, isn't it true that turbine 68 is referenced as being somewhere in parcel 9 is 156 acres, and somewhere in parcel 16 is 80 acres in the original petition?
That's correct.
And you guys narrowed it down today?
Yes, we have.
Okay, so where's it going to be now?
Per this layout for the Siemens 113, that turbine would be projected for the parcel number 16.
Okay, is that in one of these diagrams?
Absolutely, under T68, numerically in Exhibit A.
And likewise, in regard to turbine 82, the original petition indicates that it's somehow going to appear on the Joseph's property, 80-acre parcel, which is identified as parcel 38, as well as, looks like the Waltons, 157 acres on parcel 43. Have you narrowed it down now?
Yes, we have. That projected for the Siemens 113, that would be on, hold on a second. On the parcel number it looks like this might have a slightly different breakout of PIN numbers, as if something might have changed with the sale of the property since then.
And actually, that flipped to turbine 82. It appears now it's on Mr. Reese's property.
That's correct. Again, I'm not positive on that.
So the petition is completely wrong as it relates to turbine 82. It's neither on the Wallace property depicted by the legal description, nor on the Joseph property and its legal description, correct?
In terms of, as a petition in the real time of that, I believe what had happened was, I believe, and I could be wrong, that this parcel broke off some land and has now been labeled with a new PIN.
So the notice that went out in this case, and these were just three of them we picked at random, but the notice we went out in this case identifying the legal descriptions for those three turbines was wrong, correct?
No, at the time of the notice, I believe it was correct.
So, again, you can change, you want to change the location of your turbines at any time. And therefore, the notices that went out to adjacent property owners was just a guess, right?
Absolutely not. In fact, that process has been thoroughly scrubbed at the time of the notice.
Well, what about the adjacent property owners to Mr. Reese's property? He wasn't in the original notice. His legal description wasn't. So do you know if parcel 202830003 next door received the required statutory notice?
I'm comfortable in saying that yes, it did, as we went above and beyond the adjacent statutory notice to go a half mile away from each parcel.
You're comfortable with that even though it was just this moment that you realized that turbine 82 is actually on a completely different parcel than it's identified in your application, right?
Yes, I'm comfortable with that.
I'm glad you are.
All right, Mr. Porter.
Isn't it true that Mainstream has not selected a specific turbine?
That's correct.
Mainstream has not done any noise study, any shadow filter study, any environmental study, any avian study, any study whatsoever related to a specific turbine.
That's incorrect. We've done our study